Well, thank you all for coming. My name is Chris Katropia. I'm at the University of Richmond, part of the IP Institute, and this is the 13th annual Evil Twin Debate. We've been doing this for a couple of years where we've been joining up with the AALS IP section, so thank you to Anne and everyone there for letting us kind of glob on to all the IP events at the AALS event. As some of you all may know, some may not, the Evil Twin Debate Series, which was founded by Jim back in 2006, is under this concept that there are those out there, IP scholars, experts in their field, they're at loggerheads on a specific substantive topic, but we have a very nice, friendly community, and they're friends right once the debate is done. And so we said, well, you know, it'd be really neat to kind of get these individuals together to talk about a topic, have a little fun, right, but have some substance, right? So the kind of theory of this was kind of lighthearted in tone, but serious in substance. And I think we've got another one of these great debates tonight. And so our debate topic today is going private. Can the law be owned? This topic will focus on the copyrightability of law in general, a topic that's made kind of even more salient by the recent Supreme Court hearing in Georgia versus Public Resource Org. I also happened to look at the theme, I guess, for this AALS session. I didn't know that we had themes every year, but we do. This debate actually fits with the theme. I maybe need to go back and see if we've accidentally fallen on this before. But I think it does fit with this idea of pillars of democracy, law, representation, and knowledge. And so we're fitting in with all this stuff. So we have our two evil twins today. We've got Christopher Yu at the University of Pennsylvania Law School and Shyam Balganesh at the University of Pennsylvania Law School as well. This is our first intra-school debate. We'll see if it's our last. I'm not sure. And so Shyam will get 15 minutes to set up the issue, present his argument. Christopher will get 18 minutes to present his position, and then Shyam will get 3 minutes to rebut. We'll then open it for questions and have some more drinks. Now, kind of per Evil Twin tradition, and I'm so glad that they were kind enough, we'll see if they're still happy enough to kind of be involved in our tradition of allowing each of the Evil Twins to write the other Evil Twin's biography. And allowing me to read it. So at least there's like a degree of separation, right, between the two of them. So here we go. This is Shyam's biography of Christopher Yu. Christopher Yu is the John H. Chestnut Professor of Law, Communication and Computer and Information Science at Penn Law, and one of the nation's leading authorities on law and technology. One of the most cited scholars in administrative and regulatory law as well as intellectual property. His major research projects include studying innovative ways to connect more people to the internet, right? Using technological principles to inform how law can promote optimal interoperability, protect privacy, improve security, improve internet routing architecture and copyright theory, and, of course, net neutrality. Yu splits his time almost equally between being on the ground in one place, sometimes Philadelphia, but only half in Philadelphia, and the other time being in the air in transit between different destinations, seeing that no single airline had a frequent flyer tier sufficient to suit his international and intergalactic adventures. He instead chose to simply accept the highest frequent flyer status on 3 instead. He's also building innovative, integrated, interdisciplinary joint degree programs designed to produce a new generation of professionals with advanced training in both law and engineering. But despite being at the forefront of law and technology, Yu remains a Luddite when it comes to his own personal technology. He recently reluctantly gave up his old flip phone, only when it was no longer compatible with wireless networks, and now refuses to use Twitter, all mobile payment systems, or Facebook. His Facebook page reads, Christopher Yu has no friends. The price you pay, right? Yu is known for his contrarian views on a variety of issues in IP as well as law and technology, something he cherishes and loves, arguing over without making it personal. Legend has it that he began this contrarian streak as a toddler, and when his mother recognized it, she taught him the art of smoothing over any disagreement by offering his interlocutors and debaters a personally baked cake each time. He probably has a strawberry frosted one hiding in his bag for this very occasion. So now that we know Christopher a little better, right? Okay, so now we have Christopher Yu's biography as Shyam. Shyam Balganesh is a professor of law at the University of Pennsylvania and Christopher's partner in crime at the Center for Technology, Innovation, and Competition. During his youth, he prepared for the back and forth of debate by being a world-class table tennis player. When told that time had come when he had to choose between his academic studies and his sport, he embraced the mantra that anything worth doing is worth overdoing. I like that one. Earning law degrees from NLSIU Bangalore, Oxford, and Yale. Since then, he's become one of the nation's leading copyright scholars, amassing such an impressive record that he's left his Penn colleagues struggling to explain to their dean why they can't be more like Shyam. His biggest current challenges are preventing people from thinking his most recent articles are simply the fiction that is now the focus of his wife's. I guess she writes fiction. Is that okay? And discouraging people from referring to his son Marky as the Dalai Lama. I need to see a picture, I think is there. Although he has not said so directly, being characterized as Christopher's twin, evil or otherwise, has no doubt created at least some sympathy for President Trump's call for making libel cases easier to prove. So suits might prevail at this. So there we go. We know our debaters. The floor is open to Shyam to get us started for 15 minutes.
Thank you, Chris, and thank you to Chris and Jim for putting this together and for having us. Thank you all for coming. And thank you to Christopher for doing what we do 3 doors down from each other publicly now. So here goes. So we're going to talk today about the question of the copyrightability of law, focusing on this 19th century copyright doctrine known as the Government Edicts Doctrine. And what I'm going to do is set up my position on what the Government Edicts Doctrine is, where it comes from, how it works, how it applies in this now current Supreme Court case and some possible extensions for it, and where I think that the doctrine should be going and where it is analytically rooted in a way that isn't fully captured in the existing jurisprudence. So the Government Edicts Doctrine is referenced and originates in many ways in language from Wheaton versus Peters, 1834, but is given full exposition in 2 late 19th century cases decided in 1888, Banks versus Manchester and Callahan versus Myers. Both these cases were decided by the same justice, a little-known justice, but we all know him in some ways, and I'll tell you in a minute why, Justice Samuel Blatchford. Both cases conclude that judicial opinions themselves are uncopyrightable. But Banks versus Manchester concludes that the statements of the case and headnotes are not copyrightable as well, whereas Callahan finds the opposite. And the rationale for this difference is that in Banks versus Manchester, under Ohio law, these portions of the opinion, even though they're not binding as such, are prepared by the judges themselves. And so they're considered judicial work, whereas in in Illinois, in the Callahan versus Myers case, these elements are prepared by the court reporter, not by the judge, and they're therefore not considered judicial work. So the basis of the doctrine is in many ways whether it is work emanating from the judge. Now, both these cases were decided by Justice Samuel Blatchford in 1888, 2 weeks apart from each other. Now, Justice Samuel Blatchford is an interesting personality for the following reasons. In 1854, Blatchford helped set up a law firm that is then known as Seward, Blatchford, and Griswold, which a few years later comes to be called Cravat, Swain, and Moore. And so he becomes a very successful law firm partner, following in the footsteps of his grandfather, and is very successful in New York. But here's the additional interesting thing about Justice Samuel Blatchford, which we have to keep in mind when we're thinking and reading Banks versus Manchester and Callahan versus Myers, because it seems as though there's this conflict of interest variation that existed in the 19th century. Between 1851 and 1888, Justice Samuel Blatchford was also the principal court reporter for the circuit courts in the Federal District of New York. In other words, he had a very lucrative side practice of publishing opinions delivered by the federal courts in the Second Circuit, even after being elevated. So what he knew about very, very clearly and very intimately from personal practice was how judicial decisions were reported. What are the parts that court reporters produce? What are the parts that judges produce? What are the kinds of prohibitions that exist in what the judges produce? And very importantly, in this period, in 1851, he reports on what continues to be the leading New York case on the copyrightability of judicial opinions called Little versus Gold, which forms the basis in many ways of the determination of what parts of the opinion are copyrightable and not. The whole basis of Little versus Gold is some parts of the opinion are produced by a reporter gratis, and other parts are produced because they're obligated, and we need to draw a distinction in terms of the incentive structure of reporters. Okay, that's about just a Samuel Blatchford, and we're forced to sort of make sense of what he says, because now we have this case called Georgia versus PRO, or the public.resource.org. So the question that makes its way up in this case is whether annotations contained in an official state code prepared by a commission that is directly constituted and supervised by a state legislature, and these annotations are then merged and published in a unitary volume by the legislature as the official code of the state, are copyrightable as such, or whether it's only the laws that are rendered uncopyrightable. So in other words, the key question is whether the annotations produced by this commission under the supervision and through these processes are copyrightable. And I believe that the answer is unambiguously no. Right? I think these are clearly uncopyrightable, but I want to be very clear. I don't think this is the case for policy reasons. One of the arguments that's been made, including in a New York Times op-ed, is that the law is uncopyrightable. These annotations are uncopyrightable for democratic reasons of access to law, for democracy, for reasons having to do with the protection of the rule of law and notice. I think those policy concerns are not irrelevant, but they're not the primary basis for why we have the government edicts doctrine. I think as a matter of internal principle in copyright law, we have the government edicts doctrine, which produces a more coherent rationale for why the government edicts doctrine renders these kinds of works, namely works of law, or that are produced under the lawmaking authority or ostensible lawmaking authority, uncopyrightable. I think the answer really lies with the fact that copyright has a fairly clear conception of what copyrightable authorship means. And my logic derives from the fact that I think three fundamental principles in copyright law coalesce to produce the government edicts doctrine. The first is copyright's commitment to authorship. It actually means something, contrary to what we may think in light of the statute. Two, the copyright law's treatment of functional expression. And third, the merger doctrine. So first, let's deal with authorship. I think a government actor exercising its lawmaking authority, either actually or ostensibly, is not acting as an author. I think that's the fundamental proposition that motivates the government edicts doctrine. And why is that? Copyright's commitment to authorship is generally understood as entailing a critical element of personalization. What do I mean by personalization? I think it's important to understand that I'm not offering here a metaphysical theory or some kind of deontological theory about originality requiring a personal imprint or none of that. What it simply is an individuation that authorship entails to the agent producing the work. The individuation is a critical component of what I describe as personalization, embedded within this conception of authorship. Now, government lawmaking is by its very nature an impersonal act. It's an act ex officio. Yes, we care about which judge authored an opinion, but we don't care about that judge because of that individual nature of the judge. The judge is speaking in the voice of the court. Government edicts assume their value because of their ex officio status. The identity exists, don't get me wrong, they're human actors, but the personalization is consciously negated. In other words, government edicts are about impersonalization, which is contrary to our idea of authorship. Second, law, legal code, is entirely functional expression. In fact, I would even go so far, echoing Breyer in the oral argument, to suggest that legal code is performative expression. It's a performative, put very, very simply. In other words, it's a method of doing something. It's a method of inducing behavioral compliance, inducing behavioral modification. And copyright law, for the longest time, without exceptions, only subject to statutory exceptions rather, has had a very deep discomfort with functional expression. Expression that is more in the nature of a performative rather than something that has expository content on its own has always been kept to the peripheries, and to the extent that it's been brought in for policy reasons. And obviously what I have in mind is computer code, without clear statutory guidance, I don't think we would automatically, from a functional point of view, start thinking about computer code as copyrightable literary expression. We would think about it in terms of functional expression. It's the policy exception that renders us comfortable with treating functional expression as protectable. The third is a more straightforward doctrinal argument that in a legal edict, the content of the directive and its expression are merged. In other words, in the law, what the law is in terms of its directive and the way in which that directive is expressed are both merged. They can be expressed only in one way. Now, what do I mean by they can be expressed only in one way? Of course, any law can be expressed in a million different ways. But each time, especially with a statute, is expressed differently, it loses the element of authenticity. You don't have to really buy this argument if you're a textualist, but if you're not a textualist, you still have to agree that to the extent that we move from recognizing fidelity to the actual language of the law in a statute to paraphrasing it to say something else, we are replacing word choices that are made consciously in the law. The belief that the underlying expression and the directive for behavioral modification have to happen in a certain way because of the premise of authenticity motivates the idea behind law. And I think that is first and foremost a working of the merger doctrine. So it's a coalescence of these three ideas that together produce the government edicts doctrine. It is not a question of policy. Now, if one applies this framework to the code annotations, what we see is that it's not a significant extension of the doctrine. What we have in this case is the Code Revision Commission producing this code under the direct supervision of lawmaking authority, where, again, the impersonalization is coming about because the Georgia legislature has supervised the production of this code, and after it's produced, actually votes in its legislative capacity to enact it into law and merge it with the actual statute. Granted, and this becomes an issue in the oral argument, they're not voting on each individual provision. Granted, the provisions in the annotations are not binding as law, but neither of that is irrelevant. What is relevant is the fact that it's produced under ostensible lawmaking authority, that it is in fact classified as official code of Georgia annotated. It's not the official code of Georgia and annotations that follow as a supplement. It's the official code of Georgia annotated. The official carries over to not just the provisions of the code, but also to the annotations. So each of these elements is quite squarely met. Now, I want to be very clear. I am not poo-pooing policy concerns. Okay. So very, very true that a case like this and the government edicts doctrine more generally raises concerns about public policy, access to the law, notice, the ability to have prior notice before a law is actually rendered applicable to you. My concern with making the policy argument the principal basis of the government edict doctrine is the following. When we're dealing with policy concerns, one of the fundamental things we know is that there can be countervailing policy concerns that Congress can come in and say, it is our fundamental prerogative to change. We here have, in many ways, a pre-statutory doctrine, a doctrine that originates from, in my view, what copyright is about, what copyrightable authorship is about in a pre-statutory sense. Neither of these cases make reference to the statute. So the government edicts doctrine has a legitimate existence quite independent of the statute and quite independent of policy concerns that Congress can come in and modify. Here's, in reality, what I'm resisting. The idea that Congress tomorrow comes along and says, all right, these poor states, they need an economic incentive to produce their laws, and without it, they wouldn't produce their laws, and people in those states would be in anarchy. You can see Congress making that kind of an incentive argument, and therefore, the policy behind the economic incentive to produce these laws outweighs the policy concern with needing to give complete notice through full wholesale reproduction allowances, and therefore we will override the government edicts doctrine. I don't think that that is allowable in light of the way in which the edicts doctrine is embedded within our very conception of what copyright and authorship is. But here's the more vexing question, which is not going to come up in the Georgia versus PRO case, and I'm going to flag this because I think this may also represent a point of disagreement between your evil twins, which is the question of privately produced codes, right? An issue that we don't have in this particular situation in Georgia, where a private actor or a private group produces a set of model codes, sometimes with the clear expectation that they will be adopted by a municipality or other government body, right? sometimes without that expectation. And then if it comes to be adopted and not just referenced, but enacted directly, verbatim, by the municipality or government body, what should be the status of that? Now, all of a sudden it's become law, but the original author was not the government entity. And this is what comes up in the Vec case, where the Fifth Circuit holds that, no, it's not copyrightable. But the Vec case is a little bit problematic in that the Vec case ties the logic of the case to whether the private body producing these codes intended or were motivated to actually have it be enacted into law. Now, we would agree that in a situation where in a law review article, which at least I, when I read a law review article, don't expect a municipality or a government to adopt and enact into law verbatim. So when that happens and I assert copyright over it, and tomorrow a municipality comes and enacts it verbatim, what is happening there is a taking in some ways, right? Where you are being denied copyright protection for something that had copyright protection in its inception. That is fundamentally different from a situation, I believe, where you create something either under an express or implied delegation, or, and I'm ready to go this far, a motivation that it would indeed be enacted verbatim. So if you're a private entity that is actually regulating all the actors who would come to be regulated by the enactment, I think there's a significant expectation, if the municipality is known to do this, that it would be enacted verbatim. In that situation, I think, to the extent that we're looking for analogies, the enactment by the legislature or the municipality amounts to the equivalent of the public trust doctrine, right? Which is really the workaround in property law to takings. In other words, a recognition that handing over what is effectively a public function to a private entity does not entail the need to compensate the private entity when it is rendered into public ownership. On the other hand, when it had private ownership, because it was not produced with that expectation, supervision, or motivation, I think there's a stronger argument to say that there needs to be compensation on the back end when it is enacted into law. There we go. Thank you.
Well, thank you. I'd like to extend my thanks to Jim and Chris for making this possible, and for Shyam for agreeing to do it with, be a part of this. It's a lot of fun to be here, and I always enjoy talking with Shyam about different things. So I always learn so much from his take on things. And as he said, I have a contrarian take, perhaps. I suppose we all think that. But it's my own way of. All right. So. What I want to thank, I'm going to make 3 points today. And the first one involves what is at issue and what is not at issue in the case. And then the other two are pragmatic concerns, which we have to think about how they're going to affect, or should they affect the way we decide the case. So if you read the news coverage of this case, it's terrible. If you read the blogosphere about this case, it's terrible. Why? They say with great outrage, oh, it's about access to the law. These bastards want to take it away. How could they? And it's not what this case is about. And to Shyam's credit, and to which I wish I could say all amicus did as well at this point as Shyam did in his amicus, he understands that that's not really what it's about. No one is suggesting, not the petitioners or anyone, that there should be a copyright in legally binding law. You cannot copyright statutes. You cannot copyright cases. And everyone agrees to that. Now, the flip side of this is there is also a simultaneous agreement that you can copyright a bunch of other stuff. Okay? So if you go back to Banks and Callahan, courtesy of the conflict of interest justice who's still making revenues off this, who did not recuse himself for reasons that are probably consigned to history at this point, he says you should be able to get copyright in the titles, tables of cases, headnotes, indexes, statements of facts, and arguments of counsel if they were prepared by the reporter. If the judge prepared the headnotes, no. Even if they're not officially part of the binding part of the law, but you should be able to do that, and everyone agrees to this. Second, in Howell, there's a case that's probably the closest one to this. It's a Court of Appeals case called Howell versus Miller, decided by the first Justice Harlan while he was writing circuit, where there was a Michigan code where in 1882, a guy named Howell wrote the annotated statutes of Michigan. And in 1883, the state of Michigan thought they were so good, they said, we will take the this annotation shall be received in all courts as evidence of existing law as if published by the state. So essentially giving it legal effect after it was drafted. And basically he said, but despite the fact that you've given its official imprimatur, yes, the code itself cannot be copyrighted, but the marginal references, the notes, and the digests all still belong to Howell. And so this is the world we're in, where even if you, and in the case of Banks versus Callahan, these were state employees, reporters hired, paid for by the government to do their jobs. They still have copyright in the reports. And the copyrightable, the non-judicially created parts of the reports. And then going to the legislative history, and both sides agree that these two studies are what matter the most. There's a 59 study done in Congress and a 61 report issued by Congress. They're saying other material prepared by the state, including annotations, can be copyrighted. In 61, they had the report. They said annotations, headnotes, commentaries added to official documents can be copyrighted. And the current compendium of the Copyright Office says annotations that summarize or comment upon legal materials can be copyrighted. So now we have two fairly clear points, I think, that both sides of this debate agree to. You can't copyright binding law. You can copyright annotations and interpretations of law, which every law professor in this room is grateful for. Not that we get rich doing that, but hell, it's something. So the question is, in the world, what you can see is, in the Georgia case, it's not just an annotation, it's an annotation that eventually was officially voted on by the legislature. But the statute contains a disclaimer that says these annotations do not have the force of law, don't cite them, and they've done this really weird straddle. Now, we're going to have, in this case, a decision about whether what the government has done is enough to make it, to use the words of the 11th Circuit in this case, sufficiently law-like to bring it within the Edicts doctrine or not. To me, as a law professor, the outcome of this case is the least interesting part. Because what really I care about now is the rule. So this is going to be an intelligence test. Georgia says, okay, you can't copyright it that way, so we just won't pass this statute officially exonerating it. And we're going to have this whole spectrum of behavior where states are free to take more or less formal action endorsing it. Or maybe they just call it the official code and take no further action, or Shyam might even say even calling it official code is a problem. It's not entirely clear, but we have to think about that whole spectrum of activity where that legality of getting control of your annotation ends and the legal obligation to make it all public begins. And we're going to have to create a world where we're going to have to draw extremely difficult lines. And it's going to be a really interesting one because the ones that Shyam is inviting us to think about looks at the intentions of authors and the natures of authorship. My read of the cases is they tend to take a much more formal analysis, not looking at what the author did, but what the legislature did in terms of what official sanction they give it. And it's an interesting question of rule design about what we think these disputes are going to be looking like in litigation. It's one thing to talk about the official actions of government going back to, think, Chadha-like. They argue in the briefs about presentment and bicameralism and the like. If we start talking about things like the intentions of authors, whether they thought these were going to be adopted as codes or not, this trial is going to look very, very different. And what's really interesting is, I've talked with him about, we were talking about this over dinner tonight to try to think this through. If we're really looking at intentions, we're going to look at a whole range of mixed intentions. So people often will have the idea that they're doing it purely out of interest, but maybe they make a little money off it, great. Or in a repeat play game, Howell himself did his first code in 82. Statutes passed by Michigan in 83. When he revises and updates this code, he can say, I didn't know in 82 this was going to happen, but you can't tell him he doesn't know that there's going to be some financial benefit. The statute, that Michigan passed a law saying you have to cite this thing. Or it becomes an intelligence test where it says, oh, no, I'm doing it for the love of this. Anyone who suggests otherwise doesn't know, and it becomes, a question of how candid do you want to be. And so you start to see this really interesting question about how we want to structure the rules and what we think these disputes are going to look like. And there becomes a really decent administration of justice argument to say, let's get this nice rule that focuses on what the legislature does instead. And it's an interesting question to me whether we think how this is going to work out. And what's also what's fascinating to me is the practical considerations. To throw two of them here. One is, in the 1961 hearings and cited in the petitioner's brief, and cited in this brief stated by states, they made a great point to say, look, if states are going to give private publishers the incentives to produce annotated codes, we need to use copyright as an additional inducement, otherwise we're not going to get it. And the states brief represents that 1/3 of all states do this now. And so the interesting question we face is that if we take this off the table, the economist to me says there will be some marginal impact on the number of annotated codes produced, because obviously whoever is doing this is going to generate some revenue. Some people will still do it. There may be some impact on quality, but somewhere along the line, there's going to be less money for them to do this. And so what you're going to see is there'll be fewer finding tools, and there's going to be an inevitable impact of how we're doing that. And we have to do that with both eyes open. And I know we're lawyers, and copyright law says X, and we read the text, and we're supposed to ignore things like consequences, but they matter. Especially if we're framing this whole thing in terms of the context of access to the law, and just giving them a bunch of reporters ain't going to do it. We need the finding tools. That's why we bore our students with legal research as part of their legal writing skills part. If you can't find it, you can't use it. So what's really interesting is we have now two competing visions about how we could finance this. We could refuse all copyright to this and let the government pay for it on a commission basis entirely, and let it go off into the world and go freely. Or we could allow some other balance to happen in between. And the tough question we have to ask is, should we have a strong prior of which world we're going to live in? And could we have a world, for example, if the state wanted to, I assume dealing well with this, they could give a straight subsidy to people and then put it in the public domain. And there would be, the question is, if that's an intermediate solution, does the fact that they give a subsidy to have someone to do it, but retain no further editorial control over it, is that enough to bring it within the rule of the public edicts doctrine? And that's going to be a tough question, and I will say the rules that are being proposed by the petitioner and the US government who intervened as on the side of the petitioner, they're pushing different tests. And they don't lead to the same place, and it's going to be potentially a mess if the Supreme Court doesn't lay out something that makes sense. Last point I'll make. Shyam and I sort of agree and sort of disagree on the ability of a state to pass a code that incorporates someone else's copyrighted work. And in fact, you see this most commonly in municipalities. The most common form I'm familiar with is building codes. There is a company that makes building codes, they collect information, and dozens, if not hundreds of cities across the country cite it, incorporate it by reference as their building code. It is law. And Shyam says, what we should do is, if it's really properly copyrightable, that's a taking, and you can do that, but you have to pay them compensation. Now, what determines whether it's copyrightable? Again, intention. And we're going to have the same sort of problems here about determining what those sorts of intentions are likely to be. So the question I've got in my mind is, if the people who are enacting these codes, these city council members or whatever, fully understood what they were doing and understood by passing this law that every builder is going to have to shell out $500 for the code. And there's a recourse in the election box that if people don't like this way of financing it, you can vote the rascals out, which actually is something that works much more effectively, oddly enough, on the local level than it does at the higher levels. Is there a reason that we should categorically oppose that as a means when there is a political accountability that holds them into place? I say that with sort of a mixed feeling, because part of it is, I do understand the need of access to the codes, but part of it is just trying to figure out what rule would be workable in the alternative. Last point I'll make, which I said I'd give 3, but I'll give you 4. The one thing that I've really learned from Shyam a lot in my conversations with him about this case, though, is the importance of distinguishing between the basis of law on which you're thinking about your decision. So what most of us think about, the right of access to law, really sounds in due process. This is where void for vagueness comes in. This is where the ban on secret law is getting in, the ban on common law, criminal law, which used to be quite common. It all comes from a different set of values. Something Shyam said to me very early when we were talking about this, he said, if it's about due process, then let the due process clause do the work. We shouldn't necessarily change copyright law and bend it into something that it's not, in order to vindicate values that really lie elsewhere. Because what is copyright law really about? It's about creativity. It's about promoting creative activity and creating those sorts of incentives. And in fact, if we start distorting doctrines in copyright law for values that are outside, what we're likely to see is them cycle back into areas of copyright law which are more central to copyright law and to start to have an adverse effect. So I do think that there is a virtue here in turning nice corners, and to the extent to which all the outrage you see in the blogosphere over this case, really it's not a copyright outrage at all, it's really about due process. And I think that that's something that I think Shyam knows very well, but I think the rest of the world could do something to learn from him quite a bit.
Okay, so let me just make a couple of quick points. And the first one is, I think there is at base a fundamental philosophical disagreement, a worldview disagreement between Christopher and I. And it's that I am very, 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 very comfortable with the messiness of life, with the messiness of the common law, with the messiness of individualized litigation on a case-by-case basis. I am not fascinated by the need for a bright line rule that can be determined ex ante in a way in which we can classify things up front and avoid that messiness. I think that disagreement motivates a lot of the minute points of disagreement on this specific doctrine. So let's go to the two or three that I want to identify. The first one is, Christopher says, well, what if you take off the word official? What if it's a private entity as opposed to one that is supervised by the state legislature? My point is, great. My test is, was it produced under ostensible lawmaking authority? What does that mean? You tell me what the facts are and I'll tell you what that means. Ostensible means, under the facts of the circumstance, did you hold yourself out to be under the supervision of the actual lawmaking authority? What is the nature of your connection to the lawmaking authority, namely the legislature? Are you the actual commission? In other words, did you classify it as official because you had no connection, in which case it's fraudulent? But we would determine all of those facts. So that level of messiness, I think, is perfectly acceptable, and that's the way in which the common law works. Let's not forget, the government edicts doctrine is a common law doctrine. To try and cleanse it of its common law messiness in order to generate bright lines is not going to work. So if you want to have the doctrine that says that law is not copyrightable, you stick with the messiness. The second thing, similarly, is unmixed motivations, where I think that you're right, this is probably going to get a little bit more messy and can be gamed in terms of what were the motivations of the parties when we're dealing with private codes that come to be enacted and incorporated. I think if you look at what the VEC court did, I think there's a lesson there. The Fifth Circuit, the majority opinion by Edith Jones, she says, let's look at the nature of the organization involved. This organization is not producing these codes just for them to be published. This organization is producing these codes with the understanding that there's sort of an element of self-regulation here. There was a clear expectation that they would have obligatory or semi-obligatory status. In other words, the nature of the lawmaking authority, even if it was not de jure, was very, very much de facto because of who was being governed and the nature of the entity involved. Yes, that can be gamed by someone saying, oh, I didn't really intend it, and we have a variety of different, in my view, fantastic devices that we use in the law to scope out subjective intention. In fact, we have that in copyright law. Just look at the messy world of joint works, where we say memorialize it in a certain way, otherwise it's irrelevant. Subjective intention. We could do the exact same thing. In fact, we don't have to do it. Courts do it all the time, and they're pretty good at it. And I think that messiness is something that we can live with. So in short, I think our disagreement is that the government edicts doctrine came from a messy place. Let's not try and clean it, because the messiness is indeed what gives it its fantastic color. Thank you.
So we have some time for questions. Good, awesome.
Thank you. This is great. Is this turn on? Okay. I guess my question is primarily for Shyam, but I want to know how your theory applies to, you see it coming, ALI.
That's exactly what I was
Because, I'm working on one of the ALI restatement projects. I don't have any personal financial sexual motivation because I'm not getting paid by them. However, the ALI as a business model, as an institution, gets most of its funding from its basically publishing company. And so I'm trying to understand, based on your, I agree with the idea that the common law can be messy, but I'm just trying to think, how should we think about, in terms of your intentionality test? I mean, clearly the ALI, it's not going to be, most of the things that they do are not going to be enacted as codes by legislatures, but clearly they're writing with the hope, with the intention that judges will find them persuasive and will adopt them. And they make a big point of citing all the cases that explicitly follow restatements. So, as a test case, you might say, so when the Supreme Court in CCRN, when Justice Marshall uses the restatement of agency as the test for works for hire, did that render those sections of the restatement of agency, in your view, did it push them into the public domain? And then I guess the next question would be, is that a taking? If so, but we can leave that aside. I'm just curious about it. In your view, how would you analyze that?
Yeah, so I think that's a good question, and I've thought a little bit about it. So the ALI does a series of different things. I mean, one of them are these model codes. I think with the model codes, we have our clearest analog to the VET case. Those are clearly intended with the hope and indeed expectation that some state legislature somewhere will enact them verbatim into law, right? Those clearly, unquestionably, are your paradigm VET cases. But I think what you're asking about are the restatements, right? And the restatements have, I think, a variety of different parts. My general understanding is that to the extent that the black letter wording of the restatements are drawn from case law, and just speaking now for the example of the copyright restatement, where there's a new rule that to the extent that they're relying on the statute, they have to put it within quotation marks. I think all of that stuff is clearly drawn from the statute, and therefore is obviously rendered uncopyrightable. But your question assumes a life of its own when we deal with the comments, the editorial notes, and hypotheticals, and let's get to the CCNB example. I think in that situation, the way I see it is that the ALI holds its value out to be from a situation where judges readily adopt as law the text of the provision of the black letter themselves. In fact, the way in which the black letter is drafted is in a way that the judges would be able to directly apply it like a statute. In many ways, it's written like it's meant to be for the IRAC legal writing 1M, right? And I think the whole basis of that is directed at or reflects a motivation of direct adoption. And so, most specifically, when that happens, it loses copyright. And I think, let me just take a step back. It loses copyright. It was already denied copyright under the VEC formulation under my theory of what it would be like to treat it as a public trust. Because what it is in some ways is a motivated understanding that you're working as a branch of the government. And I think the AALS self-conception is very much that it is making law. Right? I think today, maybe not the case 70 years ago, but the ALI today pretty much knows that it's a de facto lawmaking body with a lot of judges ready and willing to accept what the ALI says because of the imprimatur of the process that involves a series of semi-lawmakers. And so I think that very clearly would have it be denied copyright once it comes to be enacted.
And to me, the clear example is Section 402A of the Second Restatement, which came from nowhere. I mean, that was pure advocacy, incorporated and adopted as law, and was intended that way. I'm sure that David Levy and Ricky Revesz would be very discomfited to hear what Shyam just said. And it's an interesting sort of question about what that would mean in terms of overall lawmaking and how it would work. I want to add one thing. I'm not opposed to messing. What the rules for standards debate tells us is there's a time for messy, and there's a time for clear. And we have a set of principles to shed that about when that is, but trying to figure out what is authoritative sources of law arguably leans towards clear than messy. And so it's just a question of, I'm sure different people could apply a messy standard to figure out and disagree with that. But I think that kind of clarity would be helpful.
So, according to Roland Barthes, the author died 60 plus years ago, so I'm a little concerned about this intentionality aspect. And I wonder why we shouldn't adopt as a sort of doctrinal rule within copyrightable subject matter that the work is uncopyrightable so long as it could be adopted.
So long as it could be adopted. Well, sure. I mean, I think in that sense, what couldn't be adopted becomes sort of a bigger question. Anything that is law-like could be adopted. It's just more messy, and with me, that's fine. We'll just have a lot more fun litigation. of what it means that it could be adopted. But let me just take a step back, because on the first part, I think I'm equally uncomfortable with intentionality. Intentionality for me is a very, very narrow slice of what's going on with the VEC type cases. In fact, it's not even intentionality, it's about motivation, which is significantly more objective than I think a subjective conception of intentionality would have. So it's not connected to authorship as much as what are you really trying to do here in this organizational setting that's regulating these things. But could it be adopted? I think is a great test, and we probably, my guess is, as somewhat of a legal realist, we'll end up in the same place.
I love the critical theory interpretation of
So I'm still trying to figure out which of you is evil.
They can both be.
Yeah, I think that's actually the answer to that. So I want to pick up on the ALI example, but in a different respect, because in your responses on that point, I heard both of you sort of indirectly, if subconsciously, express sort of a Schrodinger's cat. Kind of, it's simultaneously not copyrightable and copyrightable all at the same time, and we don't quite know until we open the box. In the sense that it might be born copyrightable, but it might become uncopyrightable if the black letter is actually formally adopted by a court. So I wonder if you talk a little bit about, not about what I think in both of your commentaries I heard sort of tests or standards that are essentially retrospective. That is, how was the material produced, whether it's intentionality or otherwise, and think instead sort of prospectively, right? So my concern with the restatements, for example, is when I teach contracts, I don't like to use casebooks, so I will compile a set of cases that I download, edit, and supply to the students. I can access the UCC Article 2 if I want to incorporate that into the syllabus. If I want to share the restatement as a restatement with the students, rather than the restatement as it may have been incorporated into state decision-making, if I want to incorporate the restatement, I have to access an authorized copy that is procured via the channels created by the AALS, right? So, in practice, the actual effects of presumption in favor of copyrightability, the way it's currently structured, is to structure access to the materials, if not necessarily some access to justice sense, but sort of education of lawyers in the legal system sense. So I wonder if it would make sense for you to reflect quickly on how your different perspectives on this question might change, if at all, if you think about looking at the world as it would evolve rather than as the world has been.
Right. Can I just take up the first stab of that? I think that's a great question, because one of the things that you see in the VEC opinion, which is a little bit confusing, is that there's this discussion of the fact that the code gets adopted, and it's not clear whether the adoption is the basis of the denial of copyright or whether it's the motivation behind its very creation. There's a little bit of back and forth in the Fifth Circuit opinion in and of itself as to the moment. I think what I would be comfortable with is to say, if there's an unambiguously clear motivation that you're yearning for it to be adopted, then it's still born as a matter of copyrightability. In other words, its denial happens from the very moment of creation. That's the equivalent of a legislative bill that never gets enacted. Right? That's the equivalent in a situation in which it's not enacted. I'd be comfortable with that proposition if we're ready to go there as a normative matter. Because I think if you look at the way in which the ALI is holding itself out right now, it's basically saying, oh, great courts, please adopt what we're doing and give us legitimacy. That's effectively what they're doing. And I think when they do that, they should be denied copyright.
All right, Michael, make it easy. I'm evil. I think ALI gets its copyright and keeps it. If a court cites a provision in a case, that text is obviously in the opinion. If they incorporate part of the comments directly, and that goes. Now that may make a practitioner want to go read the rest, or a private citizen go read the rest of the comments. Whether that stuff gets incorporated or not, still very much up in the air. I got no problem with saying ALI gets its copyright and keeps it. And I guess it's to the extent to which things are really binding law. We have all these things that are persuasive law, and God help us, even law professor writings are sometimes treated as important. And the fact is that a lot of things influence what we're doing. If we're saying all that goes in, you can have that world. It's not. I think that's the worst world.
Shyam, you invoked the common law a number of times, and it does make me wonder whether, thinking about the Georgia case in particular, whether this case is in the shadow of the Rules of Decision Act and the Erie constitutional principle that there is no federal general common law. To what degree, put differently, does Chris's argument shilly-shally around the edge of ignoring what Georgia has said about the nature of its statute, right? Which it seems to me the Rules of Decision Act says we can't do in federal court. But what are your thoughts about the RDA and Erie, if any?
So I will confess to not knowing enough about the RDA. Do you mind saying a little bit more about what exactly the RDA says on this proposition?
Well, I mean, the statute says that where state law supplies the rule of decision, it shall be used in federal court. And so the upshot, I suppose, is to the degree that we're talking about a copyright question, that's a question of federal law. But to the degree that that question turns on the nature of Georgia law, it seems to me Georgia gets the last word on the nature of Georgia law, which connects it to the Erie principle.
I guess what do we mean by on the nature of law? Do you mean on the nature of the copyrightability of the law? Because Georgia has said on the nature
on
of
its officialness, on the officialness
they've already
of the
said that,
application.
right? They've already said that officialness in terms of its binding nature or not?
This is where Georgia itself is being extremely unhelpful, right? Because they're on the one hand insisting that it's official, and on the other hand insisting it's not the law. So they themselves are straddling unhelpfully.
So maybe this is going to be an unhelpful
And Chris
answer.
is whistling past that graveyard, it seems to me, in his remarks.
I just get to throw rocks at his amicus.
Here's what I think is going on. I mean, I think in a situation where you have Georgia offering a certain conception of what official is, I don't think there's any discussion of this conception of the official of authoritativeness having to do with the RDA's conception of authoritativeness. I think this is entirely a matter of being internal to the government edicts doctrine. Right? I'm not seeing in any of the amici briefs a connection to the RDA because the conception of authoritativeness has entirely one that derived from first principle. The authoritativeness in terms of either its binding nature or whether it is sufficiently law. So I'm not sure that it plays the same role as a rule of decision.
So what's interesting is I'm shilly-shallying around Georgia because I'm thinking about Michigan and how all these other things at the same time. But actually, the Rules of Decision Act is a great example. So what are we supposed to do? We're supposed to make an eerie guess. And if we don't know, we're supposed to certify it to the state Supreme Court of Georgia. And so we have a mechanism for answering all these questions. Now, the legal import of what that answer as a matter of federal copyright law still goes back to federal courts. But the Rule of Decision Act, I think, is helpful in terms of procedurally telling us what we should do. But if Georgia comes back with something that says, pretty much, we meant what we said, and we're not really going to be very much helpful, which is probably what I suspect them to do, then, I still think that looking at formalization, the formal steps of enactment is a more useful, applicable rule than the intentions of whoever drafted these things. Because it gives us it's a formal analysis. And I think that that's appropriate.
So one last short question. They have a train to catch. I hate to be the bummer.
So, Crystal Laser, I was wondering, both of you mentioned the issue of takings when you have an author who did not intend for her work to become law, and you seem to both agree that that would be a taking. And I'm curious why that is, and if there are alternatives that could be developed, because you both mentioned it seems to be a bit of an economic problem. Are there alternatives to that being considered a taking?
So the reason why I at least think of it in terms of a taking is I'm echoing, potentially wrong if you want, but this is Judge Laval in CCC versus McLeod, right? Where I think he says that we have a takings issue in a situation where something was clearly created for a private authorial purpose and then comes to be adopted, and his whole resistance to the Beck type logic, which is much more extensive than it needs to be. But I think alternatives to taking, I'm not sure what they would be like, because the one that I'm offering is in a situation where you want the enactment to produce the lack of copyright without saying that you have a temporal lag in the denial. That's the public trust doctrine. I'm hard-pressed to think of another one where you would be able to generate the same economic consequences, because at the end of the day, the denial is, to the extent that something was produced with a non-enactment purpose, a denial of a private benefit, which may have gone into the motivation. So, in terms of a quid pro quo, I'm hard-pressed to think of an alternative.
in terms of takings, it's hard to imagine if someone wrote something that was created worthily entitled to property rights, the government could possess you those rights without compensation so that massive statutes incorporating the rights. And so this is a very intuitive, it's actually, it's law. They're saying that, you know, what I was saying about Georgia could actually solve this because it is work for hire. But what we learned from takings laws is that if you're going to attach strings, you have to do so explicitly in the thing that issues it to them. You can say, look, this is what we're going to do with it, and you're out. And that would cause the taking problems because they're commissioning the work, and if they want to limit the rights of the person who's doing it, that's out. What I'm less happy with is the public trust law. And that's, I think, environmental law. This just doesn't feel like, to me, property either obtained by the government, absent the Georgia situation, if it's a purely private act. Even if it's my intention that it might do that, rather than ask, you know, whatever. Tolkien dreamed that people would write new stories in his world, and one was in despair because no one was actually going to do that. Well, yeah, he can want, though, and the fact that it happens is not really in anyone's control. I don't think that, let's say that Tolkien wanted people to adopt Sindarin as the official language of the country and only honor contracts. Do I think that is going to have an impact or make it a public trust? I don't see it has the trappings of the public trust doctrine, which is traditionally property that had to do with public characteristics or moved over, that is not defined by the intention of the author.
I think it would be a situation in which the nature of the lawmaking activity being delegated to the private body is the effect of an abdication of what is a legitimate government purpose. And that's the premise of the public trust doctrine, at least in Illinois Central. So sure, it's come to be extended by Sachs and others to newer contexts, but the whole premise is there a government functionality that is wrongfully being abdicated to a private actor? And I think to the extent that municipalities signal, hey, you code makers, go ahead and produce a code and we're going to enact it, I think there's a delegation of what is effectively a public function.
Well, but patent stuff that with the hopes of getting incorporated in this standards. And we now have rules that if you're going to go that route, you have to do a fair route, disclose all this stuff. The fact is sometimes that happens, sometimes it doesn't. I like the idea of saying, look, if we're going to do this, you could do the fair solution, which is after you've already drafted it with your full rights. If you're going to have it written in the code, you have to agree to license it on these terms. And if you choose not to, we won't actually code. I mean, that's to me the natural way to follow this through.
But that's premised on there being copyrightable or to begin.
And I guess if I write a statute, a model statute, which I think is really cool for my own reasons, or actually I have them. I think, wouldn't it be great if someone enacted this way someday? And I would go around the world, like I might go from state to state trying to talk people about copyright laws. You know, and I have that as a full intention. Does that mean that loses it?
That was your motivation to create it. Let's produce this.
I stand the test. It makes it very clear to me what the dispute would look like in terms of determining whether it's subject to copyright.
Messiness is you.
I'll leave one thought back to your idea, Joe. I want to recruit us to Shyam. The notion that there is no federal common law is fundamental, but as Shyam's work has pointed out, the word author, the definition of infringement, you know, all these bedrock concepts that we have in this statutory area is something that, you know, judges bring up. Usually pretty good judges and all that, but, you know, that's normal. And so the funny thing is we all know that the lack of federal common law is not really true. But it is a matter about state law. The interesting question here is, the way I thought this discussion might go is, this is not a statutory doctrine at all. This is the shadow of an old common law doctrine that's lived through 1909 and 1976 and all these things. But that doesn't seem to change how we interpret it at all. And I would think that Shyam would say, let's do that.
True, and sort of reacting to one of the threads in the arguments in the case is there is an attempt to try and undermine the legitimacy of the doctrine, to say it has no statutory basis. I think the petitioner is at times in the briefs trying to say, this doctrine has no real basis. You textualists, I know there's a majority of you out there, throw it out. And to the extent that one says, no, it has to do with actual copyrightability principles, it's very much right in there because the statute is built on the common law of copyright.
Thank you so much. This makes me want to
in these conversations. So we never want you all to get excitement.
Thank you.
Good time here.
So I think the bar's open for a little bit longer. Thanks for coming out.